ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. ಭಾರತದ ಸಂವಿಧಾನದ ಮೂಲಕ ಮಾನವೀಯ ಮೌಲ್ಯಗಳನ್ನ ಮೆರೆದಂತಹ ಮಹಾನ್ ಮಾನವತಾವಾದಿ, ಬೌದ್ಧ ಬಸವ ಧರ್ಮದ ಅನುಯಾಯಿ ಮತ್ತು ಸಂವಿಧಾನದ ಶಿಲ್ಪಿ ಡಾಕ್ಟರ್ ಬಾಬಾ ಸಾಹೇಬ್ ಅಂಬೇಡ್ಕರ್ ಅವರ ಜಯಂತಿಯನ್ನು ಆಚರಿಸಲಿಕ್ಕೆ ನಮ್ಗೆಲ್ಲರಿಗೂ ಕೂಡ ಇವತ್ತು ಹೆಮ್ಮೆ ಅನ್ನಿಸ್ತಾ ಇದೆ. ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತು ಮತ್ತು KSBC ಲಾ ಅಕಾಡೆಮಿಯವರು ಸಂಯುಕ್ತ ಆಶ್ರಯದಲ್ಲಿ ಆಯೋಜಿಸಿರುವ ಈ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಇಂದಿನ ಉಪನ್ಯಾಸ ನೀಡಲು ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದ ಹಿರಿಯ ನ್ಯಾಯವಾದಿಯಾದಂಥ ಶ್ರೀ ಮೋಹನ್ ಕಾಟರ್ಕಿ ಅವರು ಬಂದಿದ್ದಾರೆ. ಅವರನ್ನ ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತು, KSBC ಲಾ ಅಕಾಡೆಮಿ ಮತ್ತು ಎಲ್ಲ ವಕೀಲ ವೃಂದದ ಪರವಾಗಿ ನಾನು ಹೃತ್ಪೂರ್ವಕ ಸ್ವಾಗತವನ್ನ ಬಯಸ್ತಾ ಇದ್ದೇನೆ. ಶ್ರೀ ಮೋಹನ್ ಕಾಟರ್ಕಿ ಅವರು ಕಳೆದ ಹಲವಾರು ದಶಕಗಳಿಂದ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಹಿರಿಯ ನ್ಯಾಯವಾದಿಯಾಗಿ, ನಂತರ ಹಿರಿಯ ನ್ಯಾಯವಾದಿಯಾಗಿ ಸೇವೆಯನ್ನ ಸಲ್ಲಿಸ್ತಾ ಇದ್ದಾರೆ. ಕರ್ನಾಟಕ ರಾಜ್ಯವನ್ನ ಕಾವೇರಿ ವಿವಾದದಲ್ಲಿ ಅವರು ಪ್ರತಿನಿಧಿಸಿ ಮಹತ್ತರವಾದಂತ ಒಂದು ತೀರ್ಪನ್ನ ತರಲಿಕ್ಕೆ ಅವರು ಯಶಸ್ವಿಯಾಗಿದ್ದಾರೆ. ಇವರಿಗೂ ಕೂಡ ನಾವು ಈ ವಿಷಯದಲ್ಲೂ ಕೂಡ ನಾನು ಧನ್ಯವಾದಗಳನ್ನು ಅರ್ಪಿಸ್ತಾ ಇದ್ದೇನೆ. ಇಂದಿನ ಕಾರ್ಯಕ್ರಮ ಶುರು ಮಾಡುವ ಮುಂಚೆ ನಮ್ಮ ಎಲ್ಲ ವಕೀಲರ ಒಂದು ಮನವಿಯಂತೆ ಅಂತರ್ಜಾಲದ ಮುಖಾಂತರವೂ ಕೂಡ ಉಪನ್ಯಾಸ ಕಾರ್ಯಕ್ರಮಗಳನ್ನ ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ ಲಾ ಅಕಾಡೆಮಿ ಹಮ್ಮಿಕೊಳ್ಳಲಾಗಿದೆ. ಮುಂದಿನ ದಿನಗಳಲ್ಲಿ ಅತಿ ಹೆಚ್ಚಿನ ಒಂದು ತಾಂತ್ರಿಕ ಸಹಾಯವನ್ನ ಪಡೆದು ನಾವು ಉಪನ್ಯಾಸ ಕಾರ್ಯಕ್ರಮವನ್ನ ನಡೆಸ್ಕೊಳ್ತೀವಿ. ಅದರಲ್ಲೂ ಕೂಡ ತಾವು ಭಾಗವಹಿಸಬೇಕು ಅಂತ ನಾವು ಕೇಳ್ಕೊಳ್ತಾ, ಇಂದಿನ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಶ್ರೀ ಹರೀಶ್ ಎಸ್ ಸದಸ್ಯರು, ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತು, ಇವರು ಪ್ರಾಸ್ತಾವಿಕ ನುಡಿಯನ್ನ ನುಡಿಬೇಕಾಗಿ ನಾನು ಕೋರ್ಕೊಳ್ತಾ ಇದ್ದೇನೆ. ಶ್ರೀ ಹರೀಶ್ ಅವರೇ
ನಮಸ್ಕಾರ. ಕೇಳ್ತಾ ಇದೆಯಲ್ಲ?
ಎಸ್ ಸರ್.
ಭಾರತ ಮಾತೆಯ ಪಾದ ಪದ್ಮಗಳಲ್ಲಿ ವಂದಿಸ್ತೇನೆ. ತಾಯಿ ಭಾರತೀಯ ಹೆಮ್ಮೆಯ ಪುತ್ರ, ಕಟ್ಟ ರಾಷ್ಟ್ರೀಯವಾದಿ, ಭಾರತೀಯರಲ್ಲಿ ಸಾಮರಸ್ಯವನ್ನ ಉಂಟು ಮಾಡಲು ತನ್ನ ಜೀವನವನ್ನೇ ಮುಡಿಪಾಗಿಟ್ಟ ಸಂವಿಧಾನದ ಕರಡು ಸಮಿತಿಯ ಅಧ್ಯಕ್ಷರು, ಸಂವಿಧಾನ ಶಿಲ್ಪಿ ಎಂಬ ಹೆಗ್ಗಳಿಕೆಯ ಡಾಕ್ಟರ್ BR ಅಂಬೇಡ್ಕರ್ ಅವರ 132ನೆಯ ಜಯಂತಿಯಂದು ಅವರಿಗೆ ನನ್ನ ನಮನಗಳನ್ನು ಸಲ್ಲಿಸುತ್ತಾ ಎಲ್ಲರಿಗೂ ಅಂಬೇಡ್ಕರ್ ಜಯಂತಿಯ ಶುಭಾಶಯಗಳನ್ನ ಕೋರುತ್ತೇನೆ. ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತಿನ ಗೌರವಾನ್ವಿತ ಅಧ್ಯಕ್ಷರಾದ ಶ್ರೀಯುತ ವಿಶಾಲ್ ರಘುರು ಅವರ ನೇತೃತ್ವದಲ್ಲಿ ಪರಿಷತ್ತಿನ ಎಲ್ಲ ಸದಸ್ಯರುಗಳು ತಮ್ಮ ತಮ್ಮ ಜವಾಬ್ದಾರಿಯಿಂದ ಕರ್ನಾಟಕ ರಾಜ್ಯದಲ್ಲಿ ಇರ್ತಕ್ಕಂಥ ವೃತ್ತಿಯನ್ನು ನಡೆಸುತ್ತಿರ್ತಕ್ಕಂಥ ವಕೀಲರ ಶ್ರೇಯೋಭಿವೃದ್ಧಿಗಾಗಿ, ಜ್ಞಾನಾರ್ಜನೆಗಾಗಿ ತಮ್ಮ ತಮ್ಮ ಜವಾಬ್ದಾರಿಗಳನ್ನು ಅರಿತು ಶ್ರಮಿಸುತ್ತಿದ್ದಾರೆ. ಬಾರ್ ಕೌನ್ಸಿಲ್ಗೆ ತನ್ನದೇ ಆದಂತ ಒಳ್ಳೆಯ ಹೆಸರು ಬರಲಿಕ್ಕೆ ಕಾರಣೀಭೂತರಾಗಿದ್ದಾರೆ ಅಂತ ಹೇಳಲಿಕ್ಕೆ ನಾನು ಇಚ್ಛಿಸುತ್ತೇನೆ. ಇದರ ತಾತ್ಪರ್ಯವಾಗಿ ಇವತ್ತಿನ ದಿವಸ KSBC ಲಾ ಅಕಾಡೆಮಿಯ ನೇತೃತ್ವವನ್ನ ವಹಿಸಿರ್ತಕ್ಕಂಥ ಶ್ರೀಯುತ ಬಸವರಾಜರವರು, ಹಿರಿಯ ವಕೀಲರು, ಸದಸ್ಯರು, ಕರ್ನಾಟಕ ರಾಜ್ಯ ಬಾರ್ ಕೌನ್ಸಿಲ್, ಇವರು ಆನ್ಲೈನ್ ಮುಖಾಂತರ ಪ್ರತಿಯೊಬ್ಬರಿಗೂ ಈ ಏನು ಕರ್ನಾಟಕ ಸ್ಟೇಟ್ ಬಾರ್ ಕೌನ್ಸಿಲ್ ವತಿಯಿಂದ ಸೆಕ್ಷನ್ 6 ಸಬ್ ಕ್ಲಾಸ್ 1E ನಲ್ಲಿ ಎಲ್ಲರಿಗೂ ಲಾ ವರ್ಕ್ಶಾಪ್ಸ್ ಅನ್ನ ಮಾಡಬೇಕು, ಎಲ್ಲರಿಗೂ ಎಮಿನೆಂಟ್ ಜೂರಿಸ್ಟ್ಗಳಿಂದ ಪಾಠವನ್ನು ಹೇಳಬೇಕು, ಉಪನ್ಯಾಸವನ್ನು ಕೊಡಿಸ್ಬೇಕು ಅಂತ ನಿಟ್ಟಿನಲ್ಲಿ ಬಹಳ ಹೆಜ್ಜೆಯನ್ನ ಮುಂದೆ ಇಟ್ಟಿದ್ದಾರೆ. ಅವರಿಗೆ ನನ್ನ ಅಭಿನಂದನೆಗಳು. ಈ ಕಾರ್ಯದಲ್ಲಿ ಭಾಗವಹಿಸಿರ್ತಕ್ಕಂಥ ಶ್ರೀಯುತ S ಬಸವರಾಜ್ ಅವರವರೇ, ಈ ಜಯಂತಿಯಂದು ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲಿಸಂ, ಬೇಸಿಕ್ ಸ್ಟ್ರಕ್ಚರ್ ಅಂಡ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಮೊರಾಲಿಟಿ ಈ ವಿಷಯವನ್ನು ಮಂಡಿಸಲು ಉಪನ್ಯಾಸಕರಾಗಿ ನಮ್ಮ ಜೊತೆ ಸೇರಿರ್ತಕ್ಕಂಥ ನಮ್ಮ ಸುಪ್ರೀಂ ಕೋರ್ಟಿನ ಹಿರಿಯ ವಕೀಲರಾಗಿರ್ತಕ್ಕಂಥ ನಮ್ಮವರೇ ಆದಂತಹ ಶ್ರೀಯುತ ಮೋಹನ್ ಕಾತರ್ಕಿ ಅವರೇ, ಉಪಸ್ಥಿತರಿರುವ ಎಲ್ಲ ಬಾರ್ ಕೌನ್ಸಿಲಿನ ಸದಸ್ಯರುಗಳೇ, ಎಲ್ಲ ಅಪೇಕ್ಷಿತ ಬಂಧುಗಳೇ, DV ಗುಂಡಪ್ಪನವರ ಒಂದು ಕಗ್ಗವನ್ನ ಹೇಳಿ ನಾನು ಮುಂದೆ ಹೋಗ್ತೇನೆ. ಹುಲ್ಲಾಗು ಬೆಟ್ಟದಡಿ ಮನೆಗೆ ಮಲ್ಲಿಗೆಯಾಗು, ಕಲ್ಲಾಗು ಕಷ್ಟಗಳ ಮಳೆಯ ವಿಧಿಸುರಿಯೇ, ಬೆಲ್ಲ ಸಕ್ಕರೆಯಾಗು ದೀನ ದುರ್ಬಲರಂಗೆ ಎಲ್ಲರೊಳಗಾಗು ಮಂಕುತಿಮ್ಮ. ಈ 4 ಸಾಲಿನಲ್ಲಿ ಗುಂಡಪ್ಪನವರು ಒಬ್ಬ ಜೀವನದಲ್ಲಿ ಸ್ವಾರಸ್ಯಕರ ಬದುಕಿನ ಗುಟ್ಟನ್ನ ಎಳೆದಿದ್ದಾರೆ. ಬೆಟ್ಟದ ಅಡಿಯಲ್ಲಿ ಹುಲ್ಲಾಗಿರಬೇಕು, ಅಂದ್ರೆ ಯಾರೇ ಬೆಟ್ಟದಿಂದ ಬಿದ್ದರೂ ಸಹ ಅದು ಸುಖವಾಗಿ ಅವ್ರಿಗೇನು ತೊಂದರೆ ಆಗಬಾರ್ದು, ಆ ರೀತಿಯಾಗಿ ಒಬ್ಬ ಮನುಷ್ಯ ಇರಬೇಕು. ಮನೆಗೆ ಮಲ್ಲಿಗೆ ಆಗು, ಮಲ್ಲಿಗೆ ಒಂದು ಸುಗಂಧ ಪುಷ್ಪ. ಆ ಮಲ್ಲಿಗೆ ಯಾವ ರೀತಿಯಾಗಿರ್ಬೇಕು ಅಂದ್ರೆ ಅವನು ಮನೆಯಲ್ಲಿರ್ತಕ್ಕಂಥ ಕುಟುಂಬ ಸದಸ್ಯರುಗಳು ಅವನನ್ನ ಪ್ರೀತಿಸುವಂತವರಾಗಿರ್ಬೇಕು, ಅವನನ್ನ ಒಪ್ಪುವಂತವರಾಗಿರ್ಬೇಕು. ಕಲ್ಲಾಗಿ ಕಷ್ಟಗಳ ಮಳೆ ಸುರಿಯೇ ವಿಧಿಸುರಿಯೇ, ಅಂದ್ರೆ ಎಂತಹ ಮಳೆ ಬಂದ್ರೂ ಸಹ ಧೃತಿಗೆಡದೆ ಕಲ್ಲು ಯಾಗೆ ನಿಂತಿರುತ್ತದೆ, ಎಷ್ಟೇ ಕಷ್ಟಗಳು ಬಂದ್ರೂ ಸಹ ಅವನು ಧೃತಿಗೆಡದೆ ಅದನ್ನ ಎದುರಿಸಬೇಕು. ಅದೇ ರೀತಿ ಬೆಲ್ಲ ಸಕ್ಕರೆ ದೀನ ದುರ್ಬಲರಂಗೆ, ಯಾವಾಗಲೂ ದೀನ ದುರ್ಬಲರಿಗೆ ಬೇಡಿ ಬಂದವರಿಗೆ ಆಸರೆಯನ್ನು ನೀಡಬೇಕು. ಈ ರೀತಿಯಾಗಿ ಯಾಕೆ ಈ ಸಾಲನ್ನ ನಾನು ಈ ಸಂದರ್ಭದಲ್ಲಿ ಹೇಳ್ತೇನೆ ಅಂದ್ರೆ 19 ಮತ್ತು 20ನೇ ಶತಮಾನಗಳಲ್ಲಿ ಭಾರತೀಯ ಸಮಾಜ ಅತ್ಯಂತ ಪರಿಷ್ಕರಣೆಗೆ ಅಂದ್ರೆ ರಿಫೈನ್ಮೆಂಟ್ಗೆ ಒಳಪಟ್ಟಂತ ಒಂದು ಸಂದರ್ಭ. ಅಲ್ಲಿಯವರೆಗೂ ಭಾರತೀಯ ಸಮಾಜದಲ್ಲಿ ಅಸ್ತಿತ್ವದಲ್ಲಿದ್ದಂತಹ ಧಾರ್ಮಿಕ ಸಾಮಾಜಿಕ ಆಚರಣೆಗಳು ಪಾಶ್ಚಿಮಾತ್ಯದ ಶಿಕ್ಷಣದ ಪ್ರಭಾವದಿಂದ ಒಂದು ಪರಿಷ್ಕರಣೆಗೆ ಒಳಪಟ್ಟು. ಭಾರತೀಯ ಸಮಾಜ ಜಗತ್ತಿನ ಎಲ್ಲ ಪ್ರಮುಖ ರಾಷ್ಟ್ರಗಳ ಸಮಾಜದಂತಲ್ಲ, ಇಲ್ಲಿಯ ಜನಾಂಗೀಯ ಸಾಂಸ್ಕೃತಿಕ ಧಾರ್ಮಿಕ ವೈವಿಧ್ಯತೆ ಈ ಭಿನ್ನತೆಗೆ ಕಾರಣವಾಗಿತ್ತು. ಕಾಲ ಕಳೆದಂತೆ ಆಧ್ಯಾತ್ಮ ಮತ್ತು ಸಂಪ್ರದಾಯಗಳಲ್ಲಿ ಈ ಮೂಢನಂಬಿಕೆಗಳು, ಮೌಢ್ಯಗಳು, ಅನುಮಾನತೆಗಳು, ಅಸಮಾನತೆಗಳು ಸೇರಿಕೊಂಡು ಸಮಾಜವನ್ನ ದುಸ್ಥಿತಿಗೆ ತೆಗೆದುಕೊಂಡು, ಇದರಿಂದ ಸುಶಿಕ್ಷಿತ ಚಿಂತಕರು ಧ್ವನಿ ಎತ್ತಲಿಕ್ಕೆ ಪ್ರಾರಂಭ ಮಾಡಿದ್ರು. ಇದರಲ್ಲಿ ಪ್ರಮುಖರಾದಂಥವರು ರಾಜಾರಾಮ್ ಮೋಹನ್ ರಾಯ್ ಅವರು ಇರ್ಬೋದು, ಈಶ್ವರ ಚಂದ್ರ ವಿದ್ಯಾಸಾಗರ್ ಅವರು ಇರ್ಬೋದು, ಸ್ವಾಮಿ ದಯಾನಂದ ಸರಸ್ವತಿ ಅವರು ಇರ್ಬೋದು, ಅನಿ ಬೆಸೆಂಟ್ ಅವರು ಇರ್ಬೋದು, ಜ್ಯೋತಿಬಾ ಫುಲೆ ಇರಬಹುದು, ಅಥವಾ ಆತ್ಮಾರಾಮ್ ಪಾಂಡುರಂಗ್, ಹಿಂಗೆ ಅನೇಕರು ಈ ತಮ್ಮ ಅನುಯಾಯಿಗಳ ಮುಖಾಂತರ ತಮ್ಮ ಸಮಾಜದ ಮುಖಾಂತರ ಹೋರಾಟಗಳನ್ನ ಸಮಾಜದ ಹಿತಕ್ಕಾಗಿ ಪ್ರಾರಂಭ ಮಾಡಿದ್ರು. ಇಂತಹ ಕಾಲಘಟ್ಟದಲ್ಲಿ 1891 ಏಪ್ರಿಲ್ 14ರಂದು ಅಂಬೇಡ್ಕರ್ ಅವರು ಮಹರ್ ಜಾತಿಯಲ್ಲಿ ಬಹಳ ಅತ್ಯಂತ ಹಿಂದುಳಿದ ವರ್ಗಕ್ಕೆ ಸೇರಿರ್ತಕ್ಕಂತಹ ಜಾತಿಯಲ್ಲಿ ಅವರು ಹುಟ್ಟುತ್ತಾರೆ. ಈ ಜಾತಿ ಅಸ್ಪೃಶ್ಯತೆ ಬಹಳ ಜಾಸ್ತಿ ಇರ್ತಕ್ಕಂಥ ಒಂದು ಸಮಯ. ತಂದೆ ಸೈನ್ಯದಲ್ಲಿದ್ರೂ ಸಹ ಮಧ್ಯಮ ವರ್ಗದ ಕುಟುಂಬ, ಮಕ್ಕಳನ್ನ ಓದಿಸ್ಬೇಕು ಅನ್ನುವ ಒಂದು ಹಂಬಲ, ಈ ನಿಟ್ಟಿನಲ್ಲಿ ಶಾಲೆಗಂತೂ ಸೇರಿಸಿದ್ರು. ಆದ್ರೆ ಆ ಶಾಲೆಯಲ್ಲಿ ಆ ಬಾಲಕನ ಮೇಲೆ ಅತ್ಯಂತಹ ಪರಿಣಾಮಗಳು, ಅಸ್ಪೃಶ್ಯತೆ ಯಾವ ರೀತಿ ಆಗಿತ್ತು ಅಂದ್ರೆ ಆ ಕಷ್ಟಗಳು, ನೋವುಗಳು, ಬದುಕನ್ನು ನೋಡಲು ಆತನಿಗೆ ಸಾಧ್ಯ ಆಯಿತು. ಅಂಬೇಡ್ಕರ್ ಅವರು ಹುಟ್ಟಿದ್ದು ಹಿಂದುಳಿದ ವರ್ಗದಲ್ಲಿ, ಅದು ಭಾರತಕ್ಕೆ ಒಂದು ಪುಣ್ಯ ಅಂತಾನೂ ನಾವು ವಿಶ್ಲೇಷಣೆ ಮಾಡಬಹುದು. ಇದರ ಪ್ರಭಾವ ಅವರ ಮನಸ್ಸಿನಲ್ಲಿ ಅನೇಕ ಕೋಲಾಹಲವನ್ನು ಉಂಟು ಮಾಡ್ತಲ್ದೆ ಭವಿಷ್ಯ ಭಾರತದ ಸಮಾನತೆಯ ಸಮಾಜಕ್ಕೆ ಬುನಾದಿ ಹಾಕ್ಲಿಕ್ಕೆ ಆಯ್ತು. ಈ ಶತಮಾನದ ಆರಂಭದಲ್ಲಿ ಹುಟ್ಟಿಕೊಂಡಿದ್ದ ಸಮಾಜದ ಸುಧಾರಣಾ ಚಳುವಳಿಯ ಅಂಬೇಡ್ಕರ್ ಅವರ ಉದಯದಿಂದ ಮತ್ತಷ್ಟು ಬಲಯುತವಾಗಿ ಎಂದರೆ ತಪ್ಪಾಗಲಾರದು. ಇದರ ಪರಿಣಾಮವಾಗಿ ಇವತ್ತಿನ ನಮ್ಮ ಸಂವಿಧಾನ. ಗಾಂಧೀಜಿಯವರು ಅರಿವಿನ ಮುಖಾಂತರ ಅಸ್ಪೃಶ್ಯತೆಯನ್ನ ಹೋಗಲಾಡಿಸ್ಲಿಕ್ಕೆ ಏನು ಧ್ವನಿ ಎತ್ತಿದ್ರು, ಅದೇ ನಮ್ಮ ಅಂಬೇಡ್ಕರ್ ಅವರು ಅನುಭವದಿಂದ ಧ್ವನಿ ಎತ್ತಿದ್ರು. ಮಾದರಿ ಸಮಾಜದ ಕನಸನ್ನು ಕಂಡಿದ್ದ ಅಂಬೇಡ್ಕರ್ ಅವರು ಕೇವಲ ಅಸ್ಪೃಶ್ಯತೆ, ಸಮಾನತೆ ಮತ್ತು ಮೀಸಲಾತಿಗೆ ಸಂವಿಧಾನವನ್ನ ಸೀಮಿತಗೊಳಿಸದೆ ರಾಜಕೀಯ, ಪತ್ರಿಕೋದ್ಯಮ, ಶಿಕ್ಷಣ, ಮಹಿಳಾ ಸಬಲೀಕರಣ, ಕಾರ್ಮಿಕರ ಕಲ್ಯಾಣ, ನೀರಾವರಿ, ವಿದ್ಯುತ್, ವಿದೇಶಾಂಗ ನೀತಿಗಳ ಬಗ್ಗೆ ಅವರು ಹೊಂದಿದ್ದ ದೂರದೃಷ್ಟಿ ಅವರೊಬ್ಬ ವ್ಯಕ್ತಿಗೆ ಮೀರಿದ ಶಕ್ತಿ ಅಂದ್ರೆ ತಪ್ಪಾಗಲಾರದು. ಈ ನಿಟ್ಟಿನಲ್ಲಿ ಇವತ್ತಿನ ದಿವಸ ಅಂಬೇಡ್ಕರ್ ಅವರ ಜಯಂತಿಯ ದಿನದಿಂದ KSBC ಲಾ ಅಕಾಡೆಮಿ ಬಸವರಾಜ್ ಅವರ ನೇತೃತ್ವದಲ್ಲಿ ಅಂಬೇಡ್ಕರ್ ಅವರ ವಿಚಾರಧಾರೆಗಳನ್ನ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಅಲ್ಲಿ ಬರೆದಿರ್ತಕ್ಕಂತಹ ವಿಚಾರಗಳನ್ನ ಮಾತನಾಡಲಿಕ್ಕೆ ಶ್ರೀಯುತ ಮೋಹನ್ ಕಾತರ್ಕಿ ಅವರನ್ನ ಕರೆಸಿದ್ದಾರೆ. ನಾನು ಅವರಿಗೆ ಅಭಿನಂದನೆಗಳನ್ನ ಸಲ್ಲಿಸ್ತಾ, ಸರ್, ಓವರ್ ಟು ಯು ಸರ್. ಮೋಹನ್ ಕಾತರ್ಕಿ ಅವರು
ತಮ್ಮ ಅದ್ಭುತವಾದಂತ ಪ್ರಾಸ್ತಾವಿತ ನುಡಿಗಳಿಗೆ ಧನ್ಯವಾದಗಳು. ಶ್ರೀ ಮೋಹನ್ ಕಟರ್ಕಿ ಅವರನ್ನ ಉಪನ್ಯಾಸ ನೀಡಲಿಕ್ಕೋಸ್ಕರ ಕೋರ್ತಾ ಇದ್ದೀನಿ ಸರ್. Yes, sir. I'll ask you to unmute.
Yeah. Shall I begin?
Yes, sir. Yes, sir.
Yeah. At the outset, may I thank Karnataka State Bar Council and in particular my friend Basavaraj for inviting me to deliver a lecture on this important occasion, that is birth anniversary of Sri Baba Saheb Ambedkar. Baba Saheb Ambedkar has been very dear to all of us, particularly for the lawyers, for the kind of legal scholarship he had. Besides, he was a great politician and a statesman who fought for the rights of depressed classes in India and who helped with all his scholarship to draft one of the finest constitution for India. I have special connection to Dr. Baba Saheb Ambedkar. Not that I had met him. I was born much after he passed away. But there are certain connections in a sense. My senior, Sri M.C. Bandare, who was also governor of Odisha, was very close associate of Ambedkar. Ambedkar's son and Mr. Bandare were classmates in the school throughout. As such, Ambedkar had a special affection for my senior, and my senior keeps on telling so many anecdotes, his interaction, his talks with Ambedkar. Some of them are really interesting. Besides that, I also have some kind of a familiar connection with Ambedkar. Dr. Ambedkar was very fond of Dharwad. When he came to Dharwad for a treatment and stayed there for 3 months, he decided to start the hostel for the depressed classes. One of my close relation, T.T. Mudireddy, came forward and donated, in those days in 1942, 4,000 rupees, which is almost equal to about 2 crore rupees as on today. And also, we have certain people who had briefed Ambedkar and which are the reported decisions in Bombay High Court, like Mr. H.F. Reddy, who was also practicing in Karnataka High Court after the reorganization of states, used to tell us the stories. Mr. Hiregoda, a very prominent advocate Dharwad, used to narrate the stories of his interaction with Ambedkar. So by this process, I feel I have been able to understand Dr. Ambedkar not only as a scholar, even at a personal level. That helps in understanding more about his personality. With this introduction, may I proceed to the important topic which has been assigned to me by Basavaraj to speak on the constitutionalism, basic structure, and constitutional morality. These three are very well-researched topics. To complete any lecture on them in a matter of 45 minutes is not easy, but I endeavor to do that to the best of my ability. Before we get into the concepts, let us recall what is the state and the political ideology which shaped the growth of concept of state historically. Because when you talk of constitution, it presupposes the existence of a state. But we should not look at the constitution as just a drape around this state. To understand the constitution meaningfully, we must crack into the state and see how it was formed, what are the political ideologies that govern the state, because the constitution as a legal document, as a political pact, is finally an outcome of the state. Historically, political thoughts has several schools. To begin with, politics was state or government-centric. The discourse was confined to moral principles founded in religious scripture or natural law, which monarch should adhere to be virtuous in the eyes of governed. During the age of enlightenment in the 17th and 18th century, the ideas of liberalism brought individuals to the center stage. So the focus of politics shifted from what is expected of a ruler, that is to be virtuous, to the protection of individuals, their liberty, equality, and dignity. Aristotle thought humans are social animals and that the police or state existed to bring about the good life. Thomas Aquinas thought in his Treatise of Law that God has gifted the man with a higher reason, which demands righteous government. However, English philosopher Thomas Hobbes and Leviathan was the first to articulate the concept of social contract as the basis for the foundation of the state. This is very important because the Constitution takes its shape from the social contract theory. Hobbes said that all the legitimate power, political power, must be representative and based on the consent of the people. So with this, the concept of sovereign power being born in the divinity, sourced from the divinity, was given up. John Locke argued that each man has a natural right to life, liberty, and property, and governments must not violate these rights. Locke wrote that freedom of individuals can be subject only to laws made by the legislature that apply to everyone equally. Locke invented the concept of limited government. Locke made a profound influence on the legal system and constitutionalism. English jurist Dicey fine-tuned the concept of rule of law. The social contract theory matured into a liberal school of thought. The idea of political power is not a divine power or it has source in divinity, a limited form of government, and the government is bound by law led to the emergence of written constitution. Undoubtedly, Locke influenced the framing of US Constitution in 1787 as a political pact between the people and the government. The US Constitution changed with changing liberal values. To start with, the US Constitution didn't have the guarantees given to the people in the form of fundamental rights. But as the political thoughts changed in the world, the US Constitution was amended to incorporate the guarantees, various guarantees to people, protection, due process, equality, and so on. Indian intelligentsia has been a part of political thoughts historically. From Chanakya to Gandhi, India has immensely contributed to political discourse. Chanakya's work on Arthashastra is a classic on the art of government. He stands on par with Plato and Aristotle. Though India missed the contribution to the liberal movement, Gandhian thoughts in the 20th century on non-violence as a method to redress the grievances of the people against the colonial or oppressive users are the mainstay of international political order. Following the US model of the written constitution, the Indian constitution is a political pact between the governed and the governing class. The preamble starts with "We the people." Dr. Ambedkar was very keen to start the constitution with "We the people." The Constitution of India was enacted by the Constituent Assembly. The representatives in the Constituent Assembly enacted it. The power to enact the Constitution in India came from the British Parliament, which transferred the sovereign power under the Indian Independence Act 1947. With regard to the princely states, as you all know, like Mysore, they voluntarily signed accession and became part of the process of framing the constitution. But Ambedkar said, and rightly, that this is a constitution framed by the people because we proceed with the assumption that sovereignty lies with the people. That's how we start with "We the people of India." And finally, in one of the last provision of the Constitution, we repeal the Indian Independence Act, saying goodbye to the colonial rulers. It's a very interesting legal discourse. Why Indian Independence Act repeal was mentioned at the end, and why we start with "We the people." Then we also say the Constituent Assembly enacts the Constitution. The liberal political thought that gives primacy to the individuals to uphold their freedom, equality, and dignity is not without challenge. We should be very clear that the world is not only governed by liberal thoughts, there are challenges to the liberal thoughts also. The 20th century saw a challenge by communism to the liberalist form of limited government. The beginning from the October Revolution in 1917, overthrowing Tsar Kingdom in Russia. The revolution led to the establishment of the government of the working class or proletariat. However, communism as political thought lost its steam with the collapse of the Soviet Union in 1990. But it's not over. Liberalism has come under renewed attack from the religious conservatives and nationalists around the world. The fundamentalism has put serious challenge to the liberal constitution. We need not much get into the political side of the constitution, but this is the background under which the constitutions work, under which the constitution breathe, under which the constitution function. Now let us understand what is constitution. Constitution is a political pact, when you say, social pact. Before the constitution concept came as a legal document, it was more an empirical document. It was descriptive. But as legal minds developed, the constitution became normative and rule-based. So once the constitution became a rule-based, written constitution came, United States of America, and that has followed in most of the countries. So rule-based constitution today, which we all have around, has a special significance because it binds the government. It's not only an advisory in that sense, as it used to be in the olden days, before the modern constitution was invented. Now it is a binding instrument on the government. Further, the concept of judicial review, which again we owe it to Mr. Ambedkar because of his effort, India adopted not only judicial review against the administrative action, which was quite popular in England, the English jurisprudence, but also against the legislative action. And as a result, we have, as today, a Supreme Court, which is called one of the strongest court in the world because it can judicially review legislative actions, and it goes ahead, it can even review the constitutional amendments. Therefore, the Constitution and the Supreme Court are considered to be the strongest in the world. Among various definitions of the Constitution, one definition which still holds good, according to McIlwain, which is noted in the book Beyond Constitutional by Nico Krish. He says, the most ancient, the most persistent, and the most lasting of the essentials of the true constitutionalism still remain what it has been almost from the beginning, the limitation of government by law. So going back to the concept, the rule-based constitution, that limitation of the power by law is the central aspect of the Constitution. Now let us proceed to the three concepts which are supposed to discuss today. That is basic structure of the Constitution, constitutionalism, and constitutional morality. As far as basic structure is concerned, it is seen as a limitation on the power of the Parliament to amend the Constitution. Amendment of the Constitution is a part of the process. No constitution can be permanent. It has to have a clause to amend the Constitution so that the new ideas, new experiences in the life of the country are adopted. New challenges are faced. Therefore, a clause to amend the Constitution is always necessary. In fact, most of the modern thoughts, the guarantees, equality, freedom, due process, all these were incorporated in the US Constitution drafted in 1787 through the amendment. So amendment is necessary to keep the Constitution as a living document for decades and centuries. But fear has been developed that what happens if the Parliament or the legislative body which has been empowered to amend the Constitution becomes autocratic, and by use of that power, it in fact goes ahead and abolishes the Constitution itself. Can that happen? Technically speaking, it can happen. So to prevent that, what step to be taken was the thought process which engaged the constitutional scholars in 60s and 70s. There are three types. One is express provisions restricting the amendment of the Constitution. The Constitution of Germany in Article 79 has adopted this principle, limiting the power of the Constitutional Assembly or their legislative body to amend the Constitution on certain fundamental principles. So basic structure theory, that there are certain features which are fundamental to the Constitution, which cannot be amended, is a part of the express provision of Constitution in Germany. Now it is also an express provision of the Constitution in Bangladesh under Article 7B. Bangladesh Supreme Court consistently ruled that basic structure is a part of the Constitution. Finally, the parliament in Bangladesh decided to incorporate it as a part of the Constitution, to put it on a higher pedestal, to declare to the public that this parliament will never amend the Constitution, which will take away the basic structure, which will take away the basic feature of the Constitution. The second concept is implied limitations. This is very important because most of the constitutions which have been drafted in 50s and 60s, or even later also, do not provide for express limitation on the power of amendment or say anything with regard to the basic features. So this basic structure, basic feature doctrine has to be read into the amending power of the parliament or the legislative body. And in this, India became the first country to do that. We all look to the Keshavananda Bharati case as the case which a majority of 7-6 incorporated the doctrine of basic structure as a limitation on the amending power under Article 368 of the Constitution. It is read as an implied limitation. To read something as an implied limitation by process of interpretation is not easy. But the Constitution bench, 7 judges thought this is very essential to protect, preserve the Constitution, and therefore they are justified in reading as an implied limitation. So with introduction of basic structure as an implied limitation, certain broad principles of the Constitution, like federalism, which guarantee the autonomy to the state within the assigned field, the separation of power, the representativeness in the government, the independence of the executive, independence of several institutions, fundamental rights, which are foremost in developing a society based on liberty, equality, and fraternity. So these are the basic structure of the Constitution. These principles, the constitutional provisions which enforce these principles, cannot be amended, is the message which the Supreme Court gave in its historic ruling in Keshavananda Bharati in 1973. Based on the doctrine of basic structure, several amendments have been struck down in India, and the most important is NJAC, that is National Judicial Appointment Commission. The 99th Amendment to the Constitution, which empowered the Parliament to create National Judicial Appointment Commission by incorporating Article 124A, B, and C, has been struck down by the Supreme Court on its understanding that it violates the basic structure of the Constitution, namely supremacy of the judiciary, the primacy of the judiciary in the appointment of judges. One may not agree, one may agree, that's a different matter. But that is the principle which the Supreme Court enunciated when it struck down the constitutional amendment. As I said, Bangladesh has also adopted basic structure doctrine, and finally the parliament has amended the constitution to make it as an express provision in the constitution itself. In Pakistan, there was ambiguity with regard to the incorporation of the basic structure. But finally, in the constitution petition matter in 2015, the majority, it is ruled that basic structure doctrine applies, and therefore the amending power of the Pakistani parliament is restricted by basic structure doctrine, and therefore it cannot change the basic features. I must tell you that the first court to, in fact, say something on the basic structure was Pakistan Supreme Court. In the case of Sajjan Singh, Justice Mudolkar, who was the first Indian judge to speak of basic structure in his concurring opinion, refers to the decision of Pakistan Supreme Court in Fazlul case decided in 1963, where Justice Cornwallis, if I remember, had spoken about the basic structure doctrine. If I also remember, I was not able to lay my hands, that Cornwallis in his judgment refers to the Cooley on Constitution, Cooley on the Treatise of Constitution, where there is a discussion with regard to the basic structure doctrine. So that's how the basic structure doctrine was adopted in India. Recently, in Jan Abhiyan case relating to the reservation for economically weaker sections, Justice Dinesh Maheshwari, in his judgment, who wrote a judgment for the majority, has referred to German scholar Conrad, who spoke about the basic structure doctrine in his lecture at Banaras Hindu University. But as I said, it goes a little beyond that. Mudolkar himself had referred to it in his judgment, and that is based upon what Supreme Court of Pakistan had referred to in its judgment. Now we see that even Supreme Court of Kenya has adopted the doctrine of basic structure, but it has progressed further. It says that there are 3 levels of constituent power which have to be exercised in the amendment of the Constitution. According to the Kenyan Supreme Court, the constituent power, the secondary constituent power, the Kenyan Supreme Court has accepted the basic structure doctrine, true, but it has a different line of reasoning than what the Supreme Court of India has said. We have a straightforward approach in reading the basic structure as an implied limitation in the power of the parliament to amend the constitution. But the Kenyan Supreme Court holds in para 474 of the judgment that sovereignty of the people, sovereignty of the nation lies with the people to amend the constitution, and it is exercisable by 3 methods, namely primary constituent power, secondary constituent power, and the constituted power. The Kenyan Supreme Court further holds that the basic structure can be changed only by exercise of the primary constituent power, which involved civic education, participation of the people, and the referendum. The Kenyan Supreme Court consequently denies power to the Kenyan Parliament to amend the constitution, as well as Kenyan people to amend the constitution by simple referendum. It is only a referendum which was initiated after public education, after extensive public participation, and after giving a gap of time to the public to think over that, then a referendum held after that can only amend the constitution. So it is something less than a revolutionary method, because despite all the limitations on the power of the parliament to amend the constitution by basic structure, we cannot say that constitution cannot be changed by a revolutionary method. It can be. Revolution is a legitimate source of power in creation of a state. If it is a legitimate source of power in the creation of a state, certainly it is a power in enacting a new constitution. But that's a different thing. If you go by the legal method, that is the amendatory method, then this doctrine of basic structure will hang. If you take the Kenyan Supreme Court, it's possible to amend the basic structure also, provided it is done by a referendum, and the referendum provided it is preceded by participation of the people, etc. So that's how it is put. Now there is a third method, third limitation on the amendment of the power. Supra-constitutional method it is called. What is the supra-constitutional? Supra-constitution is the international law and natural law theory. The supra-constitutional method to amend the constitution or to as the limitation on the constitution, not amendment, which acts as a limitation automatically, is international law. If the international law is accepted by the majority of the nation as something as a customary rule of international law, then it automatically acts as a limitation. We still don't have the international parliament to make international law. So there is no really a fear that there can be some extra constitutional body higher than the Constitution of India or Parliament of India, which can make a law and diminish the powers of our parliament, or it act as a restraint on our constitution. But still, there is a growing scope for interference of the international law on the constitution. And in fact, the Constitution of India itself says, whatever the international law, we must respect. Therefore, international law is being seen as supra-constitutional method to limit the operation of the constitution. The other one is natural law theory. There is a growing liking for the natural law theory. Many jurists have said that you cannot amend the constitution as you like. There is something called a higher law, that is the natural law. Natural law, as you all know, initially was considered to be a gift of divinity. Then it changed. Then it became a matter of reason. What is considered to be a rational is the natural law. So that acts, what is rational, acts as a limitation on the constitution. And the constitution by amendment cannot take away the rights of the people, which are the natural rights of the people, like equality, liberty, fraternity, and dignity. So this is one way of limiting the constituent power by applying the natural law theory. But so far, no court has accepted this, but this is being debated. Now, the next concept is constitutional morality. What is the difference between the constitutional morality and the basic structure? This is another principle which has come to govern the interpretation of the Constitution. The basic structure doctrine is seen as the limitation on the amending power of the Constitution. It is read as a limitation, Article 368. And it is also being used as a principle while interpreting the Constitution so that the gray areas are interpreted in tune with the basic structure. Now, competing with the basic structure, the constitutional morality principle has been developed. Though it is not stated to be a principle akin to the basic structure, but many have said it is almost same as basic structure. Now, what is constitutional morality? Constitutional morality, according to the political scholars, has two dimensions. The substantive dimension, then another the conventional manner in which the English philosopher Grote understood. Bhanu Pratap Mehta says the constitutional morality has two dimensions. Very interesting article he wrote. He says, the substantive constitutional, to be governed by constitutional morality is, on this view, is to be governed by the substantive morality, moral entailment any constitution carries. For instance, the principle of non-discrimination. I'm reading something wrong. I'll just go back. In the contemporary usage, there are two schools of thought on constitutional morality. He says, in the contemporary usage, constitutional morality has come to refer to the substantive content of the Constitution. So, as the Constitution morality, the Supreme Court has propounded in the last decade in a series of cases, it is the substantive content of the Constitution. So that is non-discrimination, dignity of individuals, equality. These are the constitutional morality. So that's why I said it is akin to the basic structure. The second is what Ambedkar understood. And he spoke about it in the Constituent Assembly. And the second usage is, he said, Bhanu Pratap, the second issue that Ambedkar was more familiar with from the 19th century province. In this view, constitutional morality refers to the conventions and protocols that govern decision-making where the Constitution vests discretionary power or is silent. So constitutional morality, according to Grote and according to Ambedkar, who refers to Grote in the Constituent Assembly, is the convention practices which should apply where the Constitution is silent or there is a gray area which requires an interpretation. So there are two theories on constitutional morality. One is the Constitution being seen as a moral code, which you derive by looking to the philosophy of the Constitution. Secondly, is the constitutional conventions, practices, which are constitutional morality, which may not have been adopted in the Constitution expressly, but which still continue to govern. For instance, in the second judge's case, there is an extensive reference to the Constitution, the conventions that with regard to the primacy of the Chief Justice of India's views. So the many judges have said it has a convention, it has a support in the convention. Since it is a convention, it has to be adopted as a part of the Constitution in the interpretation process. So two methods. The first method that is substantive content of the Constitution, was earlier echoed by Ronald Dworkin, United States of America. He says, moral code of the Constitution, that is called moral code of the Constitution. In his book on Laws, Empire, and Freedom, the moral reading of the American Constitution, he said, the American Constitution had certain moral principles. So judges, when they interpret the Constitution, when they apply the Constitution, they had to be guided more by the moral value of the Constitution in their judicial functions. Not only the letter, but also the moral value of the Constitution. That's how famous jurist Ronald Dworkin said. In fact, the Chief Justice of Indonesia, following Ronald Dworkin, goes ahead and says, we must have something called the Court of Ethics and Constitutional Ethics, the new perspective for the rule of ethics besides rule of law. I don't know much about it, but this is being quoted as rule of ethics. This is how it is understood. Now, Justice Venkatramaya, in the judge's case, refers to constitutional morality as a convention. That is, in the judgment in 1981, if you look to para 1077, he refers to constitutional morality, but he refers to constitutional morality in the sense as Ambedkar understood, which was based on what English philosopher Grote understood, that is constitutional conventions, to be used to fill up the gaps in the Constitution, to be used for interpretation of the Constitution, provided it has the force of, it has the acceptability as a constitutional convention and practice. Justice A.N. Ray also refers to constitutional morality in his dissenting view in Keshananda Bharati case. And again, he refers to Grote in support of his principle of constitutional morality. So this is how the constitutional morality has evolved in the country. And one is a substantive constitutional morality that is really a moral code of the Constitution, morality of the Constitution. Second is, as understood in a political sense, that is, besides the Constitution, there are several conventions, practices, and they also have an equal force. And the judiciary must consider them when they interpret the Constitution, when they apply the Constitution to the various situations. Now, the Supreme Court, as I said, Justice Venkatramaya and Justice A.N. Ray applied what Ambedkar thought, which was what English philosopher George Grote thought. Now, the Supreme Court of India recently has adopted the other American method, that is the moral code, that is Ronald Dworkin's. The morality of the Constitution means the moral principle. Series of cases, they start from the, if I can broadly quote them, I don't have to take really through all the cases, but these cases are Manoj Narula versus Union of India in 2014. Second, Navtesh Singh, that is in 2018. And Indian Young Lawyers versus State of Kerala, that is relating to the Sabarimala in 2019. In Sabarimala case, as you all know, the question was, what is the meaning of morality in Article 26 of the Constitution? The argument was that Article 26 of the Constitution is subject to other provisions of the Constitution. Article 26 itself says there is a saving clause, begins with subject to so and so. So morality is a word. When the question came up, what's morality? Justice Deepak Verma, Deepak Mishra, Chief Justice, said that this is not to be understood narrowly. It should be understood in a broad sense, that is constitutional morality. And the constitutional morality of India is non-discrimination, equality, protection of freedom, fraternity. Therefore, the Article 26 embodies within it the principle of non-discrimination and equality. And based upon this, he said the religious institutions cannot discriminate in the matters of admission to the temple. That is how the reasoning followed in Sabarimala case. So this is how the constitutional morality has emerged. It's a competing principle for the basic structure. There may be a time when both these principles will be merged together. And well, that is nothing wrong in that. At the moment, the constitutional morality is only used as a principle for interpretation of the Constitution to give a better meaning to the gray areas and nothing more than that. It is not used as a substantive ground to strike down any constitutional amendment, which basic structure is governs. But as Abhinav Chandrachud says, time is not far off and both will merge because both look same. So that possibility is there in near future, but that is how the law grows. Thank you very much. And I hope I didn't bore much.
Constitutionalism.
This is a little dry topic.
One subject, constitutionalism. I think few words are missing.
The constitutionalism, as we all know, is again a moral principle. It is a little different from the constitution. Everyone has a constitution. Even Idi Amin had a constitution. But constitutionalism is understood as a moral principle of constitutionality, of constitution. And this constitutionalism principle keeps changing. Now it has come to understand the constitutionalism means it's not only the power or the power of the wings of the government, various wings, executive, judiciary, and the legislature, but also the rights of the people, which act as a restraint on the government. Besides that, the constitutionalism has expanded to protect certain important institutions of the government, like election commission. And there is also a growing demand for inclusion of the armed forces in the constitution, so that the armed forces become sensitive and they ultimately consider their master is not the government, but the constitution. And the army officers or Air Force or Navy officers are made to take the oath to uphold the constitution. So constitutionalism is a moral principle of constitution to define the contours of the constitution. As I said earlier, it was only limited to understanding what is a state or the government. It expanded to include the rights of the people. It has further expanded to include other institutions which are considered to be vital for the functioning of the government and the autonomy to be given to that. So like that, so many institutional things are coming. So that is how the constitutional morality, constitutionalism has been expanding. But as now we see, the Constitution of India, as now Supreme Court has interpreted, the constitutional morality is more important principle, which has overtaken the general meaning usually assigned to constitutionalism. This is how I understand, and I hope.
Yes, sir.
This is I didn't bore you much because these are the little dry topics. Very few people who have an interest in the Constitution, passion for the Constitution like it. And then nothing like a last word, it always changes. Maybe if I speak next time, I might have a little different interpretation for the things. It's a very interesting and expanding field. Thank you very much.
So that was a magnificent speech, sir. I have two questions.
Sure.
So one is, I have heard the entire proceedings before the Kenyan Supreme High Court and also the Supreme Court. It's more of a procedural safeguard that before touching the core concepts of the Constitution or the core articles of the Constitution, you have to go through certain steps. That is the basic structure. Than the principles which are like enunciated in Keshavananda Bharti. More than that, the Kenyan judgment speaks about the steps and the protection given before the core principles are touched. Core principles were not subject matter of, I think, the Kenyan Supreme Court judgment.
Yeah, you are right. See, first, the Kenyan Supreme Court recognized the doctrine of basic structure. Then they said basic structure can be amended only by this process. And that process is what the Kenyan Supreme Court has been able to enunciate. So much of the judgment is on first how to, first the application of the doctrine of basic structure. Then if basic structure is to be amended,
yes.
That can be only done by the primary constituent power, which is referendum plus the participation of the people.
So the second one is the recent amendment carried out in the Pakistan, limiting the power of the Chief Justice, number one, to take suo motu cognizance of any issue. And second one is that every matter should be heard by the bench of 3 judges. Do you think that that's interfering with the, of course, anything can happen in Pakistan system, but do you think the power, the limitation of power in the amendment is, number one, every suo motu cognizance can be taken only by the committee of 3 judges. And second one is every matter can be heard only by the committee of 3 judges. So do you think there is interference with the judiciary in Pakistan by this methodology, sir?
This constitutional amendment does not take away the substantive power of the court. All it says is that it should be heard by 3 judges. That's all. So I don't think there is any interference as such. It is more of a regulation of the composition of the court. That's all. To that extent, I think the Constitution can say so.
Yes.
The suo motu cognizance power is not taken away. That power as a court of record, as a supervisory court of supervisory jurisdiction, which the court of record has, is not touched. It is only the manner of taking, the procedural manner is being imposed by the constitutional amendment. And I don't think it interferes into the functioning of the judiciary or independence of the judiciary in any manner.
Sir, in one of the judgments, I think there was a discussion that the doctrine of basic structure has no application in Pakistan. And why I'm saying is they almost went to the extent of saying that you incorporated the basic structure because you fought with Srimati Indira Gandhi. But for that emergency and the supersession of judges and the constant amendments made, do you think that there would have been a judgment like Keshavananda Bharti in India?
Well, I always started by saying that the constitutional developments take place in response to the political developments. Okay, see, Constitution is not to be read only as a legal document. There is a political process behind it. So if the challenges in 70s, certainly the challenge was posed to the Supreme Court. That is, do you allow the Parliament to amend the Constitution to the extent that finally what was adopted becomes completely, it changes. It is unmaking of the Constitution in the name of amendment. So do you allow that? The Supreme Court asserted its power and said there is something called a limitation, and that limitation is the basic structure. If Mrs. Gandhi had not misused the power in those days, perhaps there was no need to
Yes.
get into the doctrine of the basic structure. So this is all need-based developments, and that's how the constitution grows. That's how the courts respond. Unless the case comes while the court responds, and the case has to a proper case for the court to respond.
Any other questions? The audience can unmute themselves and ask the question to the learned speaker.
Sir, I have one now. Sir, may I?
Yeah, yes, go.
Yeah. Sir, when you spoke about rule-based constitution, would I be wrong in understanding that as, let's say, to stop the infinite regression, you draw something, this again connecting it to a basic structure, draw a line to stop the infinite regression, which will also be the genesis of the basic structure and the end, where you cannot travel beyond that. Would I be wrong in understanding that way, sir? Like, including all the three concepts. One is the rule-based constitution, then the three levels of constituent power, and the constitutional morality as the basic structure, something that has metamorphosized in the course of time. Basically, I'm speaking about Hans Kelsen's infinite regression. So would I be wrong in understanding to tie up all these concepts, that be a right approach to study this three concepts?
Yeah, say the rule-based constitution is basically incorporation of the command in the constitution. When the constitution was in a descriptive manner, there was no command. It was more of an advisory. Rule-based constitution makes the constitution binding on the government, and that becomes the higher law. In the hierarchy of the laws considered by Kelsen, the highest law is the constitution. And this became so only when the constitution is seen as a rule-making constitution, rule-based constitution. If it is not a rule-based constitution, if it is just a document which more acts as a moral code, as an advisory, then the constitution is not the higher law, and it's not the grand norm in Kelsonian sense. It is the grand norm in the Kelsonian sense because it is binding on the government. It is a rule-based constitution. It binds, whatever it speaks is binding on the person to whom it addresses. Right?
Yes, sir. Yes, sir. Yes, sir. Yes, sir.
Yeah. Anything more?
Yes, sir. Can again, sir, would it be a stretch if I were to say constitutional morality is subject to the grand norm? So long as the grand norm does not expand, you cannot include new concepts of constitutional morality until you, let's say, expand the grand norm. Is that, or is this a tool to expand?
I get your point. You want to say if constitution is a grand norm in Kelsonian sense, what is the status of this morality? Is it a higher law? Is it a one more layer of a law, which is a grand norm, unwritten grand norm, which is to be used in the interpretation of the written grand norm, right?
To expand.
I agree. But this is the debate which is being debated. For that, some people have said, some jurists, that it is so because natural law is the higher law. And if doctrine of natural law is applied, no man-made law can be inconsistent with the natural law. And the natural law guarantees all these rights of equality, liberty, and these things. And by constitutional amendment, you cannot take them away. And that is the constitutional morality, that is the basic structure, that is the higher law. But that is not being accepted. At the moment, basic structure is only seen as a limitation on the constitution amendment power and nothing more. It has not been given a higher theoretical meaning, which many of us like to understand, but it is not given. It is given just simply as a limitation or an implied restriction on the amendment power. That's all, nothing more. And it is said that it is intended by the constitution makers. That's all. Okay, not because there is any higher law to read this implied limitation. It is read as an implied limitation because this is what the founding fathers of the constitution intended.
As on that day. As on that.
Yeah. That's how it is read.
Just to simplify, the doctrine of estoppel can be now used to test the administrative actions and even to strike down some of the actions. But the law developed in Kamadhenu cattle field, that is the doctrine of legitimate expectation, has not reached the level of testing the constitutional validity of a plenary legislation. So therefore, it has its own limitations. Ultimately, as Dr. Ambedkar said, however good a constitution may be, if those who are implementing it are not good, it will prove to be bad. And however bad a constitution may be, if those implementing it are good, it will prove to be good. So with that note, I think we can end the seminar.
Just 1 second. What is the name of the person who asked the question?
He is Mr. Purushottam. He is my junior.
Okay.
He is
Good. Interesting question.
Yeah, brilliant. He is a brilliant person. He is my partner.
I like it.
Thank you.
All the best.
So, ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತು ಮತ್ತು KSPC ಲಾ ಅಕಾಡೆಮಿ ವತಿಯಿಂದ ಇಂದು ನಡೆಸಲಾದ ಅಂಬೇಡ್ಕರ್ ಜಯಂತಿ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಉಪನ್ಯಾಸ ನೀಡಿ ನಮ್ಮ ಎಲ್ಲರಿಗೂ ಕೂಡ ಜ್ಞಾನಾರ್ಜನೆ ಮಾಡಿದಂತ ಶ್ರೀ ಮೋಹನ್ ಕಾಟರ್ಕಿ ಅವರಿಗೆ ಧನ್ಯವಾದಗಳನ್ನು ಅರ್ಪಿಸುತ್ತಾ ಮತ್ತು ಮತ್ತೊಮ್ಮೆ ಅತ್ಯಂತ ಪ್ರಮುಖವಾದ ವಿಷಯದ ಬಗ್ಗೆ ಉಪನ್ಯಾಸ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ನಾವೆಲ್ಲರೂ ಭಾಗವಹಿಸೋಣ ಅಂತ ಹೇಳುತ್ತಾ ಇಂದಿನ ಕಾರ್ಯಕ್ರಮವನ್ನ ಮುಗಿಸಿದ್ದೇನೆ. ಸೊ ಎಲ್ಲರಿಗೂ ಧನ್ಯವಾದ. ಶುಭರಾತ್ರಿ.